Good day, wherever you are, whenever you are, and however you are. I greet you digitally. My name is Charlie Rose, and this is The Trial Advocate, one in a continuing series of discussions that we're having across the internet about the practice of law, the beauty of persuasion, the power of ethical representation, and the impact that lawyers have on our justice system, both civilly and criminally. This particular block of instruction is going to deal with the duty of lawyers to others. We're going to talk about what rights and responsibilities you have as a member of the legal profession or as an incipient member of the legal profession. You know, if you're a law student, you're getting ready to take the bar, you've just passed the bar, this is something that will be a bit of a review for you, but it's good to talk about because our duties have a sliding scale of importance. Depending upon who we're dealing with. Let's pull up our first slide and we'll do some talking about it in question. As a lawyer, we are not allowed to bring or defend a proceeding or assert or controvert an issue unless there is a basis in law and fact for it. It can't be frivolous. We can't bring claims that we know are invalid on their face, but I can bring a claim that may be in contradiction to the law if I have a good faith basis for wanting to make an argument that the law should be changed. So there's a limitation, but that limitation is not complete. I have to have a good faith basis for an argument of an extension, a modification, or a reversal of existing law. The idea behind this is that if we did not allow for meritorious claims and contentions to include that subset of change to the law, law would become a calcified, ossified instrument that did not respond and react to the needs of society. And in a democratic society where, to some extent, the validity of the rule of law is thought to be grounded in the will of the people, you need the ability to change law without requiring, shall we say, legislative involvement in some instances. And if you go back and look at some of the most important Supreme Court cases in the history of the United States, almost all of them were an extension, a modification, or a reversal of existing law because some group of lawyers said this is not just and we need to make a change. Now, in the same token that I can bring a claim and it'll be meritorious even if it's not grounded in current law, I can also, when defending a criminal in a criminal proceeding, when defending the accused in a criminal proceeding, or the respondent in a proceeding that could result in incarceration. Think ICE hearings, administrative law hearings, where there's a possibility of being deported or being incarcerated. I may defend the proceeding to the ultimate requirement that the state or the government meet every element of the case, even if I know conclusively that my client committed the crime in question or violated the statute in question. And the reason for that is because when we're going to take away liberty or potentially life from a person in our system, there is a requirement that the government be forced to prove every element of the cause of action to beyond a reasonable doubt standard. And that requirement supersedes any meritorious claim requirement that you might find in the model rules of professional conduct or any state rules of professional conduct. It's grounded in the idea that when the government is going to take away life or liberty, due process of law must be guaranteed. And that's just reflected here in Rule 3.1. If I look at Rule 3.2, expediting litigation, as a lawyer, I have to make reasonable efforts to expedite litigation consistent with the interests of the client. Now, sometimes the interests of the client might require the litigation to proceed at a certain speed to acquire perhaps some, shall we say, advantage tactically. As long as that does not run afoul of the needs of the justice system, the requirements of the court, or the rights of opposing counsel, I'm fine in slow playing that issue up until a certain point. I just have to make reasonable efforts to expedite litigation, and I have to confer with and identify the goals of the client so that I can consider those goals when looking at the expedition of litigation. It's just part and parcel of what we do. Now, Rule 3.4 talks about fairness, and it tells us that a lawyer cannot unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. And you should not counsel or assist another person to engage in any such act, to include paralegals or investigators. You can't falsify evidence, counsel a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. You can't disobey your obligations under the rules of a tribunal, except for an open refusal based upon a valid assertion, an assertion that no valid obligation exists. And in pretrial, I cannot make frivolous discovery requests or fail to make reasonably diligent efforts to comply with a legally proper discovery request. Now, you notice that all of these rules of fairness are talking about other folks who are involved in litigation. They're not talking about your client. And these rules are important rules, but they are subservient in the pantheon of professional responsibility rules to confidentiality of the client under 1.6. And sometimes Rule 1.6 will require you to push the boundaries of 3.4, fairness to others, because your client has, for reasons that you cannot disclose, asked you to engage in a certain manner or type of litigation. And you need to be aware of that, and you need to be aware that you can't use 3.4 to trump Rule 1.6. It's also interesting, if you go and look at the ethical cases and the disciplinary proceedings, Rule 3.4 is rarely cited, except when we've got gross discovery violations, as being a basis for censure. Shows up some, but not a lot. So this rule is really trying to deal with don't commit perjury, don't falsify evidence, don't help others do so, and don't violate discovery obligations. It's really what it's kind of getting at for us. And then it talks about what you can do in trial. You don't put forward evidence that's not valid. You've got to have a good faith basis to ask a question. You can't state personal opinions as to the justice of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of the accused. Your opinion as an officer of the court is not relevant to the proceedings. And because your opinion as the officer of a court is not relevant to proceedings, it's not your place to speak. That can be hard for some of us to wrap our heads around at times, but yet it's a core component of what it takes to have a successful justice system. And you can't have folks refrain from giving information to another party. You can't ask someone not to talk unless they're a relative or employee of your client, or you reasonably believe that their interests are not going to be adversely affected by refraining from giving such information. You also can't send them on vacation so they're not available, which, if you'll think about it for a moment, just makes sense, right? Rule 3.5 talks about impartiality and decorum. We're not supposed to seek to influence judges, jurors, or prospective jurors or other officials by means prohibited by law. Think bribery. We're not supposed to communicate ex parte with the judge, prospective jurors, or other officials during the proceedings unless we're authorized to do so by law or by court order. We need to make certain that that doesn't happen. We can't communicate with the jury or prospective juror after the jury's discharged if the communication is prohibited by law or court order, the juror has told us that they don't want to communicate, or the communication involves misrepresentation, coercion, duress, or harassment. I also cannot engage in conduct intended to disrupt a tribunal. These rules under Article 3 or Chapter 3, depending upon how your code is organized, are the rules that some folks refer to as the be nice rules, the act in a civil fashion rules. And civility is always of concern to judges and to senior lawyers. It seems like the more gray hair a lawyer has, the more a lawyer is concerned with how civil someone may or may not be. So in conclusion, just to wrap this up, guys, when we think about civility and these rules under 3.1, 3.2, 3.3, 3.4, 3.5, they're rules of civility, they're rules of conduct, they're rules of behavior. The idea behind them is that by adopting these behaviors, the system will treat both clients and lawyers fairly, and that it'll validate itself. I also want to put another idea in your head as you think about these, because they are truthfully not held in as high an esteem as the confidentiality rules, candor towards the tribunal rules, some of the other rules, such as conflict of interest. They're important, but they're really not as important because there are other rules that take precedent. Civility, if you ground it in psychological theories of persuasion, makes an awful lot of sense. When I am civil and treat other people with respect, it reflects back on me, and I get the benefit of the doubt when dealing with contentious issues, with complex issues. So approaching the practice of law with civility, with kindness, with transparency where allowed, is actually in the best interest of my client, because it creates a set of circumstances where I am more persuasive. And since the whole purpose of this is to advocate for someone, increasing my persuasiveness validates the system. Till next time, I'm Charlie Rose, and this is the Trial Advocate.